Judiciary Committee will come to order. The clerk will call the roll.
Mr. Chair, you have a quorum.
Okay, thank you. The very first bill will be the distinguished senator from Franklin, Senator Stanley. It's Senate Bill 863, Prisoner Litigation Reform Act. How much time do you need? 10 seconds? No, go ahead.
Well, you know, since it's the last day of the committee, if you want to move it right along, just move it right along. I'll do whatever you want me to do. Mr. Chair, members of the committee, Senate Bill 863, Virginia Prisoner Litigation Reform. As we know, the Virginia Prisoner Litigation Reform Act is in place, and what it tries to do is cut down on the number of frivolous lawsuits that the prisons and the Commonwealth of Virginia must suffer. But it doesn't apply, it applies to those actions brought by prisoners who are not represented by counsel, that is, pro se prisoners. This bill clarifies that the act applies to all civil actions for money damages brought under the laws of the Commonwealth, and those civil actions for injunctive, declaratory, or mandamus relief brought under the laws of the Commonwealth or federal law, with the application that in these civil cases...
Can you go a little slower?
No.
Okay.
It's Monday.
Okay.
Sure. This bill also provides that...
Are you being cheeky?
No. Yes. As long as cheeky is a good word. Yes.
It's a good word.
Okay. But this basically makes the act apply to not just pro se litigants, prisoners who are pro se, but also to lawyers that represent prisoners as well. It brings everything under one uniform system. To me, if it's good for the pro se prisoner, it should be good for the represented prisoner by lawyers. So this bill provides to all civil actions, and it also provides that the civil action must be brought in the circuit court or the city or county in which the prison is located, where the prisoner was housed when his cause of action arose. And then at the end of that piece of legislation, it also defines when there is a genuine issue of material fact, when it exists for purposes of summary judgment, clarifies exactly what that should be, so that any prisoner who suffers a motion for summary judgment knows what the standard is in which to overcome that motion for summary judgment. And that's the bill, Mr. Chairman.
Okay. Any questions to the patron of this bill, Senate Bill 863?
Mr. Chair?
Who's this? Senator Peterson? No, Senator. Senator Morsi.
Senator, is there any provision right now under current law that allows pro se prisoners to get any type of legal aid in their quest to bring what they think is an injustice to court?
Mr. Chairman, I answer the gentleman by I don't really engage in this type of litigation, so I don't truly know the answer. Of course, when you have habeas relief and those kind of things, you do have some representation, but I'm guessing
Mr. Chairman,
that this guy might know.
to help out here,
Senator Benjamin.
for the writs of innocence, you have a right to appointed counsel, not for habeas, though.
Okay. Anybody else have any questions? All right. Anybody in favor of the bill would like to speak
If
up?
anyone on Zoom would like to speak in favor, please raise your hand electronically.
Okay, state your name.
Hello. Good morning, ladies and gentlemen. My name is Anne Marie Renee. I'm with the Office of the Attorney General, and I am here to speak in favor today of SB 863. In 2021, the Office of the Attorney General's Correctional Litigation Section only had 11 attorneys and litigated to resolution over 700 cases, while also simultaneously providing counsel in over 500 advice matters. And what these attorneys need at the AG's office is an opportunity to bring to resolution cases at summary judgment like the federal system. The federal system currently allows prison cases to be decided at summary judgment for both pro se and counseled cases. And for the effective resolution of these cases, before bringing everything to trial, the Attorney General's office is asking that this bill be passed to allow summary judgment to be considered in prison cases.
Mr. Chair?
The main thing here is to have summary judgment in these types of cases.
Yes, sir, it does. As Senator Stanley mentioned, the bill does a number of other things, including defining what is, when summary judgment should be granted. But again, I think what would be most beneficial is allowing an opportunity in state courts like the federal system to bring these cases to a court for asking a resolution before taking it to a jury.
Yeah, Senator Morrissey?
Did you say there were 700 cases last year that 11 attorneys in your office worked on to bring to some type of closure?
And that was in
700?
700 in 2021. We haven't crunched the numbers.
I'm sorry, it's a busy day. How many cases?
700, yes, sir, in
700.
2021.
Right, and in 2021, of those 700 cases, how many went to summary judgment?
So those would only be the ones that were available in the federal system, and I don't have those numbers. I don't know what the breakdown is between the state cases and the federal system. But in our state courts, if there was a dispute of fact, if we didn't get it dismissed on a motion to dismiss, we were going to trial on those cases.
Madam, Senator,
one final
yeah,
question.
Senator Morrissey.
I have no idea in federal or state how many cases were resolved with summary judgment with your explanation. I'm trying to figure out if there were 700 cases brought by pro se litigants and 698 of them went to summary judgment in favor of the Commonwealth of Virginia. I'm trying to get that flavor from you.
I'm sorry, I don't have those numbers,
Okay, thanks.
Senator.
Mr. Chair,
Okay, Senator Peterson.
I'm going to ask this question a different way. How many cases involving prisoners suing the Commonwealth actually went to trial? I don't think I've ever heard of one actually going to
We
trial.
take them to trial, and I have several pending right now personally, my colleagues as well. And again, I don't have an exact number for you, I apologize.
Follow up.
Senator Peterson.
If the case trial was pending, you wouldn't be here. You'd be in a courthouse right now.
Yes.
I guess what I'm asking is, I assume almost all of these go out on sovereign immunity, or they go out on statute of limitations or something like that. How many trials, juries in the box coming back with a verdict, are we talking about?
You state your name.
Chair, Senator, if I may, Diana Botto from the Attorney General's office. I don't break down the number of state versus federal. We have more federal cases than we do state. It's probably 60-40. I would say prior to the pandemic, I did check to see how many times the attorneys were out doing hearings and trials, and they spent about 20% of their time out doing hearings and trials.
Okay, I
It's a little bit,
I apologize, Mr. Chair, and I'm looking for a precise figure. How many trials are we talking about? Jury
I
trials?
don't know. I don't keep that
Okay.
number.
Thanks.
Okay, all right. Next, you go, continue. If you have anything else you want to say?
I think that covers it. Again, we are asking for a system similar to the federal system. It is an efficient tool in the federal system to ask for a court to declare as a matter of law parties' interests, but if not, if there's a dispute of fact or if the law is unclear, it still goes to a jury trial, certainly. But we are just asking for the opportunity to, or a tool like summary judgment to bring in state courts for the efficient resolution of these cases.
Okay, anybody else want to speak in favor of the bill? Okay, anybody want to speak against the bill?
If
Okay.
anyone on Zoom would like to speak in opposition, please raise your hand electronically.
Good morning, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we oppose the bill. We appreciate Senator Stanley listening to our concerns. The Federal Prisoner Litigation Reform Act and its state counterparts, including Virginia, were enacted in response to pro se prisoner lawsuits. Pro se prisoner lawsuits filed by so-called jailhouse lawyers. They could oftentimes file these lawsuits without paying a fee, and as a result, the courts were getting flooded with all of these lawsuits. These acts were specifically tailored to address pro se prisoner lawsuits, not lawsuits filed by attorneys, not lawsuits filed by former prisoners. This bill would expand the act to an unprecedented degree. First and foremost, if passed, the act would apply regardless of whether the inmate was still incarcerated or not. I don't even know whether that's constitutional. Second, if passed, the act would apply to all prisoner litigation regardless of whether the prisoner is represented or not. The reason why it matters whether they're pro se or represented by counsel is there are procedural safeguards when someone is represented by an attorney. Sanctions, bar complaints, contempt of court. Those don't exist with inmates. Third, the bill would sweep all litigation touching upon prisoners into the circuit court where the prisoner is or was housed. So let's use a hypothetical. Inmate is housed at Red Onion, is taken by jail van to Fairfax Hospital for a complex medical procedure. The prison guard driving the van is about to make that last turn off of Gallows Road and flips the van, badly injured. Under this bill, any lawsuit from that incident has to go to Wise County. It completely changes our entire venue statute. Fourth, on a related note, under this bill as drafted, the act would apply to any claims brought by a prisoner or former prisoner, not just those claims arising out of the conditions of confinement. So let's say you have an inmate, he gets out of prison, goes to the Kroger, slips and falls. It would fall within this act the way it's drafted. I'll be quick, Senator Stanley, I promise. Fifth, under this, it gives the defendants an unprecedented, unparalleled advantage in summary judgment, as you can tell from the very last line. And we hope that you will agree to pass this bill by indefinitely. Thank you.
Okay, anybody
Chair,
else?
I got a question.
Speak? Senator Morrissey.
Can you give us, the committee, some idea of these 700 cases that were filed pro se, how many ended in summary judgment, or as Senator Peterson said, how many actually went to trial of those 700 by a pro se litigant?
Mr. Chairman, Senator Morrissey, I don't have any firsthand experience as far as Virginia is concerned, but my first job after my clerkship was for the D.C. government defending these cases as an assistant corporation counsel. And we used to get these pro se prisoner lawsuits in D.C. Superior Court all the time. Sure. During the 2 years I was there, I never saw one go to trial because I had an incredible winning record on motions to dismiss.
As I'm sure all the assistant attorney generals do as well.
Okay. Anybody want to speak against the bill? Anybody want to speak? Go ahead. Wrap it up.
Thank you. I just wanted to respond. I don't believe it's a proper interpretation of this bill or of the current PLRA that a slip and fall case unrelated to conditions of confinement could be brought or would be subject to the PLRA under this bill. Under the venue provision of the current statute, the language is no prisoner action shall be filed in which the prison is, shall be filed except in the circuit court of the city or county in which the prison is located where the prisoner was housed when his cause of action arose. So I think unless the slip and fall is happening at the prison where the cause of action arose, it wouldn't be subject to this bill. And unfortunately, I would also counter that we do have frivolous cases filed by counsel. It's certainly been my experience, and sanctions are not always an appropriate measure for that. That's not an appropriate response. A lot of the times, I think the litigation strategy will become to bury the Commonwealth in discovery.
Mr. Chair.
Senator Dees.
I would ask how many times in the past year frivolous suits were filed by counsel, and how many times the Attorney General's office asked for sanctions, and how many times sanctions were granted?
We typically do not ask for sanctions because, again, I think the litigation strategy from a case that is filed by counsel, when I think counsel realizes the case doesn't quite have the merit that he or she hoped, the litigation strategy from plaintiff's counsel will be to kind of bury the Commonwealth in discovery. And that's not necessarily a sanctionable action. So we're looking for an avenue to bring to the court an undisputed factual situation. We're asking for summary judgment in those type of circumstances.
Senator Morrissey.
Assistant Commonwealth attorneys have a responsibility to see that justice is done, unlike their defense attorney to seek out a victory. Towards that end, as an assistant attorney general, if you saw a case that you looked at and you said, you know what, this actually has some merit, do you have a ethical responsibility to try to locate an attorney for them? In other words, try to seek justice, or is your goal, your objective, to simply get that case dismissed?
Oh, certainly not, Senator. I've certainly encountered cases filed by a pro se inmate that might have merit, and I think my obligation first is to my client, and I might go to my client and discuss settlement, say, hey, I think this case does have some merit, we're looking at some liability, maybe we should discuss settlement. But the inmate certainly also has the option of approaching the court and requesting that the court at least ask for counsel for him. There's no obligation that counsel be appointed, but they can. I've seen courts in the past try to find counsel for an inmate in such
One
circumstances.
final question,
Okay,
Mr. Chair.
one final question.
You said there were 11 folk that did these cases, so let's say 65 cases per person. You're one of the individuals. How many cases did you take pro se to court to where there was a jury verdict last year?
I took, I believe, 2 to trial last year with the jury verdict. We are a little backlogged because of the pandemic still. We didn't hold any jury trials in 2020 and very few in 2021. So we're starting to set those. I'm going out on maternity leave in a couple months, and I've got 3 juries set for right when I get back. This is just kind of how we're doing
a
things.
defendant that represents himself.
Yes. Mhm.
Okay.
Mr. Chair.
Senator Deeds?
I've got a motion to very gently pass this bill by indefinitely.
Okay. Any discussion? All in favor of the motion to pass the bill by indefinitely, vote aye. Otherwise, vote no.
No, sorry, I got to vote for my own stuff, sorry.
Ayes 9, noes 4.
Okay, 9-4. Okay, Senator Stanley, you got another bill, 1472, violations of child protective orders.
Yes.
Class 1 misdemeanor.
Mr. Chairman, members of the committee, Senate Bill 1472 addresses a concern when we reformed this statute. Actually, I carried the bill that made some reformations to kind of parse out child protective orders and make them differently from regular protective orders. If someone violates a family abuse, an adult protective order, there's swift and graduating punishments already in the code for that violation. Under 16.1253.2, you have lists increasing penalties for subsequent violations there. Missing from that list, however, are any violations of a final CPO, child protective order, under 16.1278.2. There are recent changes that we made to the violation of preliminary CPOs under 16.1253J. But those protective orders are usually only good for 60 days unless a dispositional hearing is held. After that time, Mr. Chairman, the court's either supposed to dismiss the CPO, give custody to someone else, or enter a permanent CPO. And since permanent CPOs are not listed in that penalty section of 16.1253.2, and since there's no punishment listed in 16.1278.2, a violation of a permanent CPO would be only a contempt of court, which to me and to many in that field seems unjust. You understand when there's a preliminary CPO exactly why then a violation of a preliminary CPO would be in fact a contempt of court. Because you have a secondary court hearing coming after the first one where the preliminary CPO was put in place. And that way, at that second hearing, the violation could be heard. Maybe the person didn't fully understand the order or whatnot. But having the same punishment, which is contempt for a violation of a permanent child protective order, seems like a slap in the face for these children. I mean, why are there protections for under a family abuse PO better than for a child? I mean, violating the child protective order 1 time or 10 times results in only the same punishment, which is no more than 10 days in jail. And so I have looked, there's not another code section that allows justice for a child for violation of a permanent, remember what we're talking about here, permanent child protective order. And so what this does is it creates that if there is a permanent child protective order in place, the penalty for violating that, and remember, these are usually the most egregious cases, is a class 1 misdemeanor instead of a contempt of court. Okay. And that would be for every violation of the CPO. We've had cases in Franklin County where permanent child protective orders were entered in against abusive fathers who have tracked down their children, harassed them on the street, caused them undeniable angst and fear. And yet the only thing that could happen, and actually this person kind of knew it, was that the worst that could happen was a contempt of court violation. And so fearlessly, or at least not fearing that result, he then continued to harass that child. There has to be a point at the end of the stick. There has to be, when a permanent child protective order is entered, protecting the child, something that's going to stick, and it does not make that order just a piece of paper that's penetrable. And so this changes that to make permanent child protective orders, if they are violated, and a court of law finds a violation by beyond a reasonable doubt, that the person can be punished as we punish those who are convicted of Class 1 misdemeanors, and that's the bill, Mr. Chairman. Thank you.
Any questions? So
Mr. Chairman, I got a question.
Yeah, Senator Senator
Surville. Thank you, Mr. Chairman. Let me just try and frame up what we're talking about here. You said a lot there, which your statements I thought were kind of broad compared to what the bill's about. So, first of all, the language that you have here in paragraph C has to do with preliminary protective orders, not permanent protective orders. Am I mixed up there?
Yeah, I think you are. Mr. Chairman, I'd answer the gentleman, rarely, Servell, are you mixed up, but you are here.
Okay.
And again, I've worked with this with Mr. Qualiato, so he can probably explain the mechanics better.
Yeah, Mr. Chairman.
Senator Searle.
So, when I read subparagraph C, it says, any preliminary protective orders entered on behalf of the child shall be blah, blah, blah. And it says, if such a protective order, which refers to the preliminary order, is incorporated in a dispositional order, a violation of such protective order is punishable as a Class 1 misdemeanor. So, I mean, it looks to me like it refers to the preliminary order, not the permanent order.
Mr. Chairman, I'd answer the gentleman by saying that's not the intent at all. Actually, what you usually have is a preliminary protective order, and that's what it addresses. But when that preliminary protective order is then incorporated in a dispositional or a final order, which would be a final CPO, a child protective order, then a violation in such protective order, which would be the final CPO, would be punishable as a Class 1 misdemeanor.
Joe, I have a lot more questions. Mr. Chairman?
You go ahead, Searle. Go ahead.
No,
Okay, well, I understand what you intend. That isn't what it says, I don't think. And if what you're after is to make it a Class 1 misdemeanor to violate a final order, a final dispositional order, then it needs to stop saying such order. It needs to say dispositional order, number one. Number two, if you intend to apply to both preliminary orders and dispositional orders, it ought to say that instead of using such order. What is your intent?
Mr. Chairman, I'd answer the gentleman by saying I worked with Mr. Qualiato, and he probably has a better answer than I do if there's a fix that's required.
Charles?
So, Mr. Chairman, it should apply just to the dispositional orders, not the preliminary orders, because the preliminary orders have a separate penalty in the preliminary order statute. So if the change needs to be made, you can strike such a, and just put a preliminary order, if a protective order is incorporated in a dispositional order, a violation of the protective order is punishable as a class.
Okay, so moved, Mr. Chairman.
Yeah, Senator Searle.
So moved.
Hold on a second. Wouldn't it make more sense to just say a dispositional order?
Second.
A violation of a dispositional order issued pursuant to the section is a violation of a class, is a Class 1 misdemeanor?
Yep.
Wouldn't that make it more clear?
Yes.
I think so. A violation of a dispositional order issued pursuant to this section is a Class 1 misdemeanor.
So moved.
It's punishable as a Class 1 misdemeanor.
Okay, Charles, let's let Charles come up with something.
Right, I understand, Mr. Chairman, and I understand Senator Deans.
Okay, so moved.
So say it again, Charles.
Second.
How
So,
do you-
Mr. Chair, the amendment would read, if a dispositional order, if a protective order incorporated by the dispositional order pursuant to this section, a violation of the dispositional order is punishable as a Class 1 misdemeanor.
Okay, is there a motion, has a motion been made?
Again.
You got Senator Morsi, you want
No,
to?
I have more questions, Mr. Chairman. I made a motion. It's been seconded.
Just a second, okay, ready? Okay. All in favor of the motion, vote aye. Say aye. Aye. All opposed, no. Motion carries.
Mr. Chairman, I have more questions.
Senator Searle.
Thank you. Now that we got that clear about what we're aimed at, so we're talking about an order that typically says you can't abuse a child again.
No contact, usually, as well.
Okay, but, okay, it has, okay, so,
It can. I mean, you can have a child protective order that has a rehabilitation part to it, but
okay, Mr. Chairman.
there's usually,
Yeah, Senator
to keep the data.
Okay, well, listen,
Senator
but here's my point, okay, is that if the violation, whatever the violation is that this would now pick up, involves a domestic assault, an A and B, an assault on the child, that would be a separate crime, right? So what we're talking about doing it now is creating a second crime for those situations, right? So in terms of criminalizing, first of all, we're creating a second misdemeanor for certain classes of conduct, and what you're doing with this is creating a new crime for something which would otherwise only be punishable by contempt. Is that a fair statement?
Mr. Chairman, I'd answer the gentleman by, that's pretty accurate. I mean, what we're trying to do here is, when the final child protective order is in, you may have other issues, but that is a piece of paper that's supposed to keep that parent away from the kid in most occasions, in most circumstances. If they come in and violate it as they are prone to do, then the only thing that happens is just a maximum contempt and 10 days in jail.
Mr. Chairman, final question.
Okay, all right, several.
Thank you.
Final
So, I
question.
mean, I can understand why we would have the criminal consequences for adults because adults are adults and they have their own rules. But it seems to me that when you're talking about these types of protective orders involving children, the complaining party, the complaining witness for whatever it is the protective order violation would be is likely to be a parent, the other parent, the oppositional parent, who is probably trying to leverage that other parent in some custody case and trying to create consequences and also trying to create a reason to make the child custody, give them advantage in a child custody case, which is why I suspect there's like a difference in terms of how we treat these. I mean, do you have any impression about that?
Mr. Chairman, I answered the gentleman, my friend, by saying we're talking about a permanent child protective order. You've got to do some pretty significant things against your child to get because you have the preliminary one, and usually in the preliminary one, if there is a preliminary finding that lasts for a certain period of time, then it kind of goes away. It's either dismissed or it's dissolved. But there may be ongoing, continuing harassment and conduct, which warrants a final permanent child protective order. That is an order that is there to protect the child from further harassment. If we're always going to insinuate that people will use the law as a stick to beat their spouse that they don't like anymore over the head, well, we have plenty of those. But what we're trying to do here, simply put, is protect a child where there's been many layers of due process and hearings before a judge, and the judge has decided for himself, despite what disputes might be between the wife or the mother and the father, that this child needs to be protected from one or both parents, and enters a permanent child protective order.
Okay, yeah, Senator Morsi.
It's a little different than just, messing around because you don't like your spouse as you get a divorce.
Bill?
Any other questions? Senator Morsi?
Senator Stanley?
Yes.
I think I like this bill, but I want to make sure that at least that I'm clear on it. First of all, there are 3 protective orders: the emergency protective order, followed by 72 hours later with a preliminary protective order, followed by 2 weeks later a permanent protective order. What I understand from paragraph C is that preliminary protective order, okay, that happens 72 hours after the emergency protective order is issued, the court issues a dispositional order. Is that correct?
Mr. Chairman, I answer the gentleman, but usually,
The answer is yes, right?
so in the violation of preliminary CPOs, child protective orders under on Virginia Code 16.1-253J, they're usually only good for 60 days until a dispositional hearing is held, and then at that time, sometimes they're continued if there's an ongoing criminal case that is also pending. But after that time, the court's either supposed to, by code, dismiss the CPO, give custody to someone else, or enter a permanent child protective order.
Let me ask staff. Let me ask staff.
Senator Morsi.
Charles, I thought I got it, but I'm a little bit unclear. We all know that there are penalties that can be imposed for violating a permanent protective order. We get that. Is the spirit of Senator Stanley's bill to catch somebody who violates a preliminary protective order before the permanent protective order is issued? Is that what Senator Stanley is trying to catch?
Mr. Chairman, I believe what Senator Stanley's trying to catch is if someone violates the permanent order,
okay,
there is no penalty other than contempt of court right now.
Okay.
So he wants to make it a Class 1 misdemeanor if you violate the permanent order. Because under current law, if you violate the preliminary one, it is a Class 1 misdemeanor.
Thank you very much.
Okay. Anybody else have any questions? Is anybody opposed to the bill?
If anyone on Zoom would like to speak in opposition, please raise your hand electronically.
Thank you, Mr. Chair. Valerie LaRue from the Virginia Poverty Law Center, and I am opposed to this bill, and I appreciate Senator Stanley listening to some of our concerns about it. So if the committee were to look at the lines, number 2 at line 30. So one of the kinds of orders that can be entered in under this statute is an order that would permit the child to remain with his parent subject to such conditions and limitations as the court may order with respect to such child and his parent or other adult occupant of the same dwelling. Some of the things that a child protective order can prohibit or require are things like telling that parent who the child should have visitation with and when. They might also say that when the child is with dad, say, in the kind of situation that Senator Servo referenced, that let's say dad smokes like a chimney, that when the child is at dad's house, that dad will smoke outside and not in the house. And yes, if mom comes to pick up the child and the child smells like cigarette smoke, mom can say, he's violated the protective order, I'm going to go to court. So it's all very well for us to use the extreme examples that Senator Stanley has brought up. But in these less extreme examples where a parent has been ordered to take their child to therapy once a week and misses an appointment, that would be a violation of the protective order. If the parent is supposed to ensure that the child goes to school, that would be a violation of the protective order. So all of these things, from the least to the greatest situation, would be a violation and would be now punishable as a Class 1 misdemeanor. So that is why we're opposed to this bill. If it's the pleasure of the committee to pass this bill, we would ask that the committee add language, which is from the underlying order, which is that if such protective order is incorporated in a dispositional order issued pursuant to this section, a violation of such order, and we would cross out protective there based on what Senator Servo was saying, is punishable as contempt of court. However, if the violation involves an act or acts of commission or omission that endanger the child's life or health or result in bodily injury, it is punishable as a Class 1 misdemeanor.
All right. Okay, yeah, okay. All right, anybody else oppose the bill?
We have a speaker on Zoom, Mr. Chairman.
Anybody else oppose the bill?
We have a speaker on Zoom.
Yeah.
Sorry, should I go ahead?
Yeah, go ahead. Go ahead.
Hello, my name is Fallon Speaker. I am the legal director of the Youth Justice Program at the Legal Aid Justice Center, and we oppose this bill for many of the same reasons in which the Virginia Poverty Law Center has already stated. Having practiced in this area of law and child welfare, and specifically in representing parents over 10 years, I think that something that is being conflated here is the level of allegations that are generally wrapped up in the protective order. Protective orders are not just issued for allegations of abuse, sexual abuse, or physical abuse. Oftentimes they're issued for allegations of neglect, which is the predominant allegation that is in child welfare proceedings. Those protective orders oftentimes have requirements for parents, such as visitation, when you pick up and drop off, what time, what location, whether someone is supervising that visitation, requirements for taking children to medical appointments, mental health appointments, requirements for substance use or abuse programs, mental health programs for the parents and also for the child. And sometimes these requirements are such as like taking a child to school on time, or walking a child to school, or dropping them off at school. There's a wide range in which these protective orders, whether it's a temporary protective order or one that is issued as a final protective order at a dispositional hearing, is entered. The way in which this language is crafted would create misdemeanor effect for allegations oftentimes that have nothing to do with any sort of physical abuse or harm to the child, and is very broad and overreaching language. We would support the language that the Virginia Poverty Law Center has recommended should this committee decide to move forward with this bill, as that the language be amended to reflect that, but would just like to note that this is very overreaching and will likely cause a lot of parents who are simply in the child welfare system for issues of abuse for neglect to be sort of caught up in this misdemeanor language. So we would like to offer that we would object and recommend that the language be amended.
Thank you very much. Okay, anybody else have any questions? Anybody else against the bill? All right, is there a motion?
Mr. Chairman.
Yeah, Senator Sorrell.
Substitute motion, PBI, gently, and speak to that motion.
Yeah, go ahead, speak.
Thank you, Mr. Chairman. So, I think the senator's well-intentioned here, but this thing is going to turn every child custody case where one of these is involved into parents going down to the magistrate every other week trying to get a Class 1 misdemeanor issued on the other parent.
Second.
And I would just note that in the language for the preliminary protective order, the one that leads to the final protective order, subsection J says it's only a Class 1 misdemeanor if the violation endangers the child's health or life
Okay.
or bodily injury. It doesn't extend to everything. This would be like way broader than that, which is why it has issues. But
Okay, it's been moved and seconded the bill be passed by indefinitely. All in favor of the motion, vote aye. All opposed, no.
Hey, children.
Ayes 8, no 6.
8-6, the bill has been passed by indefinitely. Got one more bill, Senator Stanley. You're on a roll.
Yeah, clearly. Mr. Chairman, Senate Bill 1515 addresses an issue which I think is pervasive in our society that needs to be addressed. We as a community, and we as a governmental body, put guardrails around those things that children, those under the age of 18, should not be exposed to. Now, they're not perfect guardrails, but they're guardrails nonetheless. We have a prohibition as it stands right now of anybody under the age of 18 cannot possess or view child pornography. When we had video stores, that was pretty easy to enforce because kids under the age of 18 couldn't go in the back room. But now we have the internet. The internet that is not only brilliant in terms of what it can do for all of our lives, but it also possesses a dangerous edge to it, where pedophiles can come through never go through your front door, but can come right through your child's computer and contact your child.
How are you going to stop that?
Mr. Chair,
How you
if we
control the
could just
internet?
cut to the chase on lines 25 through 27, how do we prove damages?
Mr. Chairman.
Is it strict liability?
Mr. Chairman, there is no strict liability on there. I think the case has to be demonstrated, but this law has been successfully passed and implemented in the state of Louisiana. Over 40% of children by the age of 10 have been exposed to pornography on the internet. And so what they have done and what this does is the YouPorn, the Pornhub, and Mr. Chairman, you and I had a discussion of what is pornography. Well, I would say that if you have an internet website that has porn at the end, that's a pretty good indicator that there's pornography on it.
Senator, how do you deal with lines 28 and 29? Nothing in this section should be construed to impose liability on a provider or user of an interactive computer service on the internet. That's pretty broad, isn't it? How do you stop it?
Mr. Chairman, I disagree that it's pretty broad, but if we're...
Mr. Chairman, I mean, may
Yes,
I? Patron,
Senator
I mean,
Obenshain.
isn't that just protecting, like, Verizon or Cox?
AOL or, right.
Right, but not the site.
Right. It's the site itself. And so, Mr. Chairman, in operation of the Louisiana law, very easily, Pornhub was able to put a filter only in Louisiana that requires identification, which, identification on the internet can be had, that prevents children from accessing these websites. If we are going to sit here and allow and just say, well, there's nothing we can do about it, it's the darn old internet, then we're abrogating our responsibility to our children. Exposure to pornography to children at young ages warps their relationship development. It's degrading. It has issues with body shaming and mental health issues. There is no way that any one of us on this dais believes that children under the age of 18 should be exposing or should be freely able to access internet pornography.
Anybody want to speak in favor of the bill? Are there any questions of the patron?
If anyone on Zoom would like to speak in favor, please raise your hand. There are no speakers on Zoom, Mr. Chairman.
Anybody opposed to the bill?
If anyone on Zoom would like to speak in opposition, please raise your hand. There are no speakers on Zoom.
Then moved and second to report the bill.
Mr. Chairman.
Yeah, Senator Sherrill.
Just really quick, I just want to note that the term sexual conduct is not defined in the bill, and I have a separate bill to clarify the definition of sexual conduct in Title 18.2 under the obscenity, the Dirty Books for Minors statute, which is where I think they would pull from. And unless the House of Delegates and the governor agree to my bill, this bill makes it illegal for anybody to show, a gay couple having dinner, or creates a civil cause of action for that. And so,
No, it doesn't. Mr. Chairman, no, it doesn't.
Mr. Chairman,
Yes, Senator Sherrill, go ahead.
if you go read the definition of sexual conduct today in Title 18.2, it says that sexual conduct includes any depiction of homosexuality, not homosexuals engaged in sex, but any depiction of homosexuality. And the governor used it as standards for his library bill. That's why myself put in a bipartisan bill to take that out of that definition. the House of Delegates hasn't agreed to that yet. They actually modified it and messed it all up. But in any event, I would just want to point out that the way this is written right now, I know what you're aimed at. I know you're not aimed at that. I'm not saying you're aimed at that. But that's picked up by this unless that other bill passes.
And Mr. Chairman, I'd answer the gentleman if I can very quickly by saying on YouPorn and Pornhub, I am guessing that they don't have many videos that people can download of people eating dinner, whether they're straight or gay. But what they do have are explicit demonstrations of degrading conduct that my 10-year-old should not and will not watch. But, you know, and you may even say, well, then it's up to the parents. No, we don't do that in government. We still put guardrails around, and then we have our parents actually take the extra step. Those parents need help, and they need help in making sure that access to pornography here in the Commonwealth of Virginia will not be granted to people under the age of 18. And allow me just to say this one thing. Those sites know how to get this done because they want to avoid the civil liability. So once they put that filter on, this is over.
Okay.
And those sites that don't do it are the ones that should be.
Senator Morrissey, you had a question?
Just a comment. I agree with the patron. I don't see in what universe a gay couple having dinner would constitute sexual conduct, but I think there's a catch-all on small 2I, which says, and is patently offensive to prevailing standards in the adult community. So I think the language in lines 14 through 17 clearly constitutes some type of sexual activity that would be, that would
Anybody else have any questions?
appeal to the prurient interests of minors.
Anybody else have any questions? Senator Boysko.
Mr. Chair, thank you very much. Senator Stanley, I appreciate the spirit that this was introduced in. I also have a concern around this language being used against LGBTQ folks. And that's where I'm getting stuck on it.
Okay.
Mr. Chairman,
Could
any
we
other
have
questions?
some,
Yeah, go ahead.
Mr. Chair, I wonder if there might be some.
Chair.
Excuse me, I have the floor, I
Senator
believe.
Boysko has the floor.
Thank you. Mr. Chair, Senator Stanley, is there any, I'm just wondering if there might be any language that could be used, and perhaps our counsel could answer, that could clarify that this is not intended to either punish or put in harm literature or other thing. I know we've had a whole conversation on books that we deem as dangerous. I appreciate where you're trying to go, and I completely agree with you that kids are being exposed in very unhealthy ways to porn, very young.
Yeah.
Anybody who has access to a computer or a smartphone, the kids
And
pass it
Mr.
around.
Chair,
And it's not just the
it
book.
harms their growth and their relationship growth
It's not the
with
book, you
others.
know, when I was in the 6th grade, we had Judy Blume books that we passed around the room.
Blubber.
This is way, not just blubber, but,
Well, that's the one I read.
well, there were some other ones, but this, I appreciate where you are. I'm just wondering if there's a way we could provide some protective language in the statute that says that this is not in any way.
We got to move on. Senator Peake, you have a question?
Well, just a comment on the bill.
I'm
Mr.
sorry, go
Chair.
ahead, Senator Boysko.
Mr. Chair, I had a question for council to see if there would be a way to put some language in that would be protective for the LGBTQ community who is not, so it would not be used against them.
So, Mr. Chair, one of the things that could be done to the bill is adding in the definition of sexual conduct that is in Senator Serville's bill, which eliminates homosexuality from that 18.2 definition.
Mr. Chair.
Mr. Chair, I move acceptance of that amendment.
Speaking to that amendment.
Mr. Chair, I'd only say that pornography is pornography, whether it's heterosexual, homosexual,
Thank
pedophilia.
you. We have a motion for an amendment. Senator Peake.
Speaking to the amendment, yeah, just what Senator Stanley said, it is directed at pornography. If it's gay pornography, it's pornography. If it's heterosexual pornography, it's pornography. It's pedophilia, it's pedophilia. If it's bestiality, it's bestiality. It's directed at pornography. Everything, it doesn't have anything to do with LGBTQ unless it's pornography.
Mr. Chair.
Yeah, Senator McClellan.
Thank you, Mr. Chair. I think people probably haven't had enough coffee yet, but everybody agrees that we want to address pornography directed at children. The concern you hear is that this may be, as written, too broad and might capture more than that. So I think we are looking for an amendment that will make sure we are capturing the pornography, but are not unintentionally capturing more than that. So that's what we're trying to do. And everybody needs to dial it back a little bit.
All right.
Mr. Chairman, am I included in the dialing back part? Because I can't. Okay. But, ultimately, and Mr. Chair, I'm not, to move this through the process, what this really does, and what it should do, is put a filter on Pornhub, to where if you're going to access Pornhub, you're going to prove that you're over the age of 18, or that you're the age of 18 or higher. That's what this does. Whatever's beyond that wall, I can't describe. And I don't know what the wide-ranging thing is. It could have intimacy with a
Mr.
parent.
Chair,
I'm just trying to keep.
Mr. Chair,
Senator
procedurally, where are we? Senator Boysko's got a substitute motion to amend the bill. Is that where we are?
I think that's where we are. Okay. Is there a motion? All right, we have a motion. There's an amendment before the body.
Mr. Chair, the amendment would be to add in a definition of sexual conduct, which would match the definition in the juveniles, the sales to juveniles bill that Senator Serval amended it to, which basically, if I have to pick it up, but.
Mr. Chairman, Serval.
It would be sexual conduct means actual or explicitly simulated acts of masturbation, sexual intercourse, or physical conduct in an apparent sexual stimulation or gratification with a person's closed or unclosed genitals, pubic area, buttocks, or if such be female breast.
That's fine.
All right, it's been moved and seconded that we adopt that amendment to the bill. Everybody understand?
I'm dizzy.
All in favor of the motion, say aye.
Aye.
All opposed, no. All right, it's been moved to report the bill. Is there a second? Yes, okay. My concern, Senator, I don't have any word to enforce this bill. It's just, I don't think it's possible.
Mr. Chairman, if we
Anyway.
believe that on every instance, then we might as well just let our kids fend for themselves outdoors
No,
and tell them how to pick nuts.
I'm talking about the internet. Anyway, so I got a long story about that. But anyway, the motion is
I bet you
made
do.
to report the bill. All in favor of the motion, vote aye. All opposed, no.
Senator Edwards doesn't want
Ayes
to put in his
13, noes
information.
1.
I don't think it's enforceable constitutionally anyway.
Thank you. Thank you, Mr. Chairman. Thank you for your work on this.
We got the Serval show. Okay, abortion. Senate Bill 1243.
Great. This is the Stanley Serval Deeds docket today. So I would, if we want to take up where we left off, I think it was 1398, is that right? I have a substitute, Mr. Chairman.
1243.
Oh, 1243, I'm sorry. I have a substitute, Mr. Chairman.
Move the substitute. Second.
Okay, motion been made to remove the substitute. All in favor of the substitute, say aye. Aye. All opposed, no. Motion carries. The Senator Serval's substitute to Senate Bill 1243 is before the
Thank you,
body.
Mr. Chairman. So where this got bogged down last time was we were talking about the language in, let's see, it's lines 16 through 20. Yeah, 22, right. So, but it's changed. I changed it here. So here's what happened. Some people that are a lot smarter than me reminded me why I had this sentence in my bill. And basically, and I didn't realize this existed, but under Article 4, Section 2 of the United States Constitution, there's a restriction on the states prohibiting extradition of persons who commit crimes in the home state back to the state where they committed the crime. And the U.S. constitutional language basically says that if you, like, for example, if you commit a crime within Virginia and then you go to another state, the other state can't keep you coming back from Virginia. What the language does not say, though, is that if you're charged with a crime in Virginia, but at the time the crime happened, you were present in Maryland, it doesn't restrict the person from extradited from Maryland back to Virginia for that. So basically what we did to mitigate this was we left the language in to make it constitutional, but we also created a rebuttable presumption that says if you were a Virginia resident at the time the crime occurred, the government has a heightened burden of proof to show that you were present in the forum state to get extradited from. In other words, it makes it harder to extradite somebody back to that state if they were a resident of a different state. And that's the best we could do to sort of create that, to create some more protection for folks. So just to give you an example, you can say, suppose a Virginia doctor were to provide medication to somebody in Virginia, and then that person would drive from Virginia back to, say, Alabama. And then somebody were to try to, the patient or another person, and then say perhaps that some prosecutor in Alabama were to try to charge the Virginia doctor, or maybe the person driving the car or something like that, with conspiracy to distribute, and say, I want to extradite that Virginia doctor back to Alabama. This would prevent the governor from honoring that extradition order.
Okay. Any questions? I think we understand the bill. All right. Anybody have any questions of the patron? Anybody speak in favor of the bill?
A question over there.
Senator
We have a speaker on Zoom,
Obenchain.
Mr. Chairman.
Senator Obenchain.
Scott, tell me again how this complies with Article 4, Section 2 of the Constitution.
Because Article 4, Section 2 only restricts our ability to stop extraditions for people who commit crimes when they're physically present in another state. So in other words, you have to be, the defendant, the putative defendant, has to be physically present in, like, Alabama in order to be extradited to Alabama. And the Constitution only restricts that. But the Constitution does not restrict a Virginian who was never physically present in Alabama from being extradited. It doesn't restrict our ability to stop extradition of a Virginian being extradited to Alabama when they never set foot in Alabama.
Mr. Chairman,
Steve,
further question, if I may.
Go ahead. Yeah, Senator Obenchain.
So if, let's just say I send a bomb by mail to somebody in Alabama and kill them, you telling me I can't be extradited to Alabama?
No.
Because I never set foot in Alabama?
No.
And we passed a law to that effect?
No, we've adopted the Uniform Extradition Act, which covers that situation. What this does is creates special protections for people that are engaged in what formerly was constitutionally protected conduct until Dobbs came down. And it only does it to the maximum extent that we're allowed to under the Constitution.
Okay.
Yeah,
Okay.
I hear you, but I don't agree with you.
Senator
I
Morsi.
understand that.
Senator Morsi.
Okay. Senator Serville, in your example, be specific. What crime occurred in Alabama if a doctor prescribed some type of medication in Virginia? Or I lost you right there. What is the crime in Alabama?
Well, it could be, for example, they prescribed them an abortion medication in Virginia, they took it back to Alabama and then took it there, and then somebody charged them with a conspiracy to violate the Alabama law.
Mr. Chair.
Senator.
Okay, hold on. Wait a second. I've got
Senator
the
Morsi.
floor.
Go ahead, Senator Morsi.
So, say the Virginia doctor prescribed some abortifacient medication, gives it to him. Does he give it to him in Virginia, or does he give it to the person vis-a-vis the male in Alabama? That's the first question.
I don't think it would matter for purposes
Okay.
of this.
Second final question. If there were a hearing on extradition, wouldn't that hearing occur in the Commonwealth of Virginia, where that doctor would be able to make his or her case that what he or she did was legal in the Commonwealth of Virginia, thereby denying?
Yes, and under this bill, that doctor would not be subject to extradition to Alabama.
Okay, all right. Any other questions?
Yeah.
Senator Peterson?
Yeah, I was going to say, permission to ask a leading question. Basically, this is designed to protect OBGYNs and doctors that give advice And so that the actual medical service or the consequence may occur in another state, but the advice was given in Virginia.
Yes.
Thank you.
Okay, any other questions? Anybody against the bill?
We had someone in support on Zoom, Mr. Chairman. Lexi, you may unmute and give your testimony.
Good afternoon. This is Lexi White, Policy Director with Repro Rising Virginia. We strongly support this legislation in its efforts to add protections for providers and those assisting standard reproductive health care legally here in Virginia. We also think the bill includes critical data privacy protections for sexual and reproductive health care information. And it's important that this data does not get into the wrong hands. So we applaud Senator Serval's leadership on this, and we very much support this bill moving forward.
Anybody else want to speak in favor of the bill?
There are no more speakers on
Anybody
Zoom,
want to
Mr.
speak
Chairman.
against the bill? All right, is there a motion? All right, it's been moved and seconded to report the bill. All in favor of the bill, vote aye. All opposed, vote no. If you favor the bill, vote aye. Otherwise, vote no.
Chap, you get me?
You should be good, Senator.
It's not up here.
Ayes 9, no 6.
9 to 6, the bill, the substitute passes.
Thanks. 1244 is the next one.
Okay, Senate Bill 1244.
I think
Crime
this-
victim and witness rights.
Right, I think this one's pretty simple. What I perceived to be a gap came to my attention after a 27-year-old unarmed accountant got murdered by 2 U.S. Park police officers about 2 blocks from my house. And he was prosecuted, he was attempted to be prosecuted in Fairfax County, but the United States, well, actually, the feds refused to prosecute him, so the Fairfax County Commonwealth Attorney tried to prosecute him. It got removed to federal court, and then while the case was on appeal to the Fourth Circuit, the Attorney General took over the prosecution of the case and then immediately dropped it by consent, just dismissed the prosecution. The family of the 27-year-old unarmed accountant, who I've gotten to know very well for a lot of different reasons, but I don't represent them, I want to make that clear, as an attorney or as constituents, did not feel that they were really consulted before their prosecution against their son's murders got discontinued. And when I went and looked at the Crime Victim Witness Act, it was not clear to me that the Attorney General's office is required to comply with the Crime Victim Witness Act. And so all this does is it says that attorney for the Commonwealth also includes the Attorney General when the Attorney General is actually doing a prosecution of a criminal case.
Okay,
So
I think we understand the bill. Anybody have any questions to the patron? Anybody here to support the bill, huh? Okay, it's been moved and seconded to report the bill. All in favor of the motion, vote aye. All opposed, vote no. Okay.
Ayes 15, no 0.
15 to 0, the bill passes. Senate Bill 1495, Senator Serval, local enforcement action.
Thanks. So 1495, Mr. Chairman, in committee, is a bill to build on the good work of Senator Obenshain.
Move to report.
You got one vote. Go ahead.
For those of you who've been around for more than 7 or 8 years, you might remember that Senator Obenshain passed a law back in 2014 to create a cause of action against local governments who could pursue enforcement actions that violate the Constitution of Virginia or the U.S. Constitution. And this basically extends that to violations of state law. So it's basically aimed at code enforcement. I just also want to make crystal clear, this is not an attempt to do anything about qualified immunity. To the extent anybody might think that it goes that broad, I have zero interest in that. If anybody wants to do an amendment to make that crystal clear, I'm happy to make that crystal clear if anybody's concerned about that. But
I actually have two questions / comments, Mr. Chair.
Senator Peterson.
The first one was obviously whether or not it impacts qualified immunity. I respect that, but I think we need to at least have an enactment clause saying that this does not derogate qualified immunity. Secondly, how is this different than Section 1983 under federal law? Under federal law, if the locality has a law that violates the U.S. Constitution, or I guess it's going back and forth whether or not about Virginia Constitution, you can theoretically go into a federal court and have a cause of action.
Right.
Is this basically sort of trying to create a state law duplicate of that?
No.
No.
No, this
What's
is
the
actually,
difference?
this is actually like a lower barrier than that. I mean, first of all, any 1983 action would be subject to qualified immunity defenses or whatever.
No doubt about it.
Those can happen, and even in the civil context, but this has to do with not violations of the Constitution, but violations of state law. So if you have a locality that's violating state law willfully, the threshold here, by the way, is willful. It's not just any violation of law by the locality, it's a willful violation.
Senator, if I might, Mr. Chair.
Senator Peterson.
I actually argued this issue in front of the Federal District Court 2 summers ago and lost. So I could have used this bill a little while ago. I would move to amend to make it clear that it does not derogate qualified immunity.
Let me say one thing.
I don't know if that's in the code.
Qualified immunity is clearly a federal issue, period. It's not a state issue.
Well,
if anybody understands, it's under 1983. The federal judges in the early 1980s came up with the concept of qualified immunity. It's a federal issue. It has nothing to do with state issues at all.
Mr. Chairman.
That's why we tried to repeal it a year ago.
Yeah,
Mr.
Senator.
Chairman, I basically agree with the chair on that, that it is a federal doctrine. What I would say, Mr. Chair, in response to Chap's comments, maybe give Chap a little bit of comfort, is Section 1983 deals with persons who violate constitutional protections. This deals with localities. Section 1983 Act, I don't believe is available. I'm a little rusty, but I don't think it's available. Second of all, I can tell you that many of these actions, they hurt, but they don't hurt enough to justify bringing a Section 1983 case. And the problem that many people have is, they are subject to arbitrary actions of local government who make these arbitrary decisions because they can, and they know that you can't do anything about them. They may be failing to return a bond or something that just doesn't make sense, can't be justified, but they know that you can't do anything about it. And I think this addresses a real problem.
All right. Anybody?
Mr. Chair, if I might make one follow-up.
Senator Peterson.
And I apologize for speaking, but I've had these types of, I agree with Senator Obenchain. My other question is, and I do think this is a good bill, by the way, I'm not being critical. Why General District Court? Why not Circuit Court? It took lines 18 and 19.
Well, I thought that would be like a quick and dirty, easy place to, it could be either or, but.
Well, it says shall.
I understand what the bill says. All I'm saying is that I put that in there because I was trying to go for a place that'd be for small remedy, cheap, small, quick, dirty.
Right, but then there's a right of appeal. I would change that shall to a may if you don't object.
Yeah, I second that too. I agree. Motion's been made to change shall to may on line 18. All in favor of the motion, say aye. Aye, all opposed. Okay. Yeah, Senator Short.
A question for Senator Serval or perhaps counsel.
Sure.
How does this overlap, intersect, or crosswire with a writ of certiorari in long-standing precedent of arbitrary capricious decision-making by a locality? Because this appears to me to be potentially in conflict, or it could be in addition to.
Mr. Chairman, what I would say is this is a lower bar than that, because this only requires willful disregard, and I would say arbitrary and capricious is a higher standard to prove than willful disregard.
So, Mr. Chairman?
Yeah, Senator Short.
You've got a specific time clock if you're going to follow those procedures. Does this extend that? Is it a substitute for it? If you were to proceed down this path, you may miss the opportunity to file a writ of certiorari. I also have a question about Senator Obenchain had a bill some time ago that dealt with unreasonable restrictions in land use, and I don't know how this overlaps with that. So I think the senator is going into an area that's much more complicated than the simplicity of this bill.
Yeah, I think so too. Yeah, Senator Serval. Anybody?
Mr.
Yeah, Senator
Chairman.
Morrissey.
Senator, Senator, this is a follow-up to Senator Stewart's bill. Normally, wouldn't this be handled by a writ of mandamus directing a superior court to tell an inferior court to do something where it is, to use your words in the bill, a willful disregard of applicable law?
Senator Sherrill?
Yeah, I think absent this statute and absent conduct that's as egregious as 1983, your only remedy would be to court, probably go to circuit court, seek an injunction. And you also would not be able to recover attorney's fees, which is an important sort of way to level the playing field in these situations. 'Cause, these local governments have armies of lawyers, free lawyers at their disposal on their payroll, and often with, real people.
Follow-up and final question.
This can be expensive.
Senator Morrissey, go ahead quickly.
Scott, would this be in addition to a writ of mandamus, this new legislation?
Yeah, absent a language in the bill that says writ cert is out, it would be in addition.
Thank you, Mr.
Stewart.
Mr. Chairman, Senator Morrissey's correct. There are situations where you would use a writ of mandamus. Generally, you'd use a writ of certiorari. And again, as I said, there's a specific timeline for that. What concerns me is if someone goes under this statute, they're going to miss their timeline to file a writ of certiorari, and they're out of luck. I mean, it's statutory. It's absolutely statutory to take those steps to get where you need to be to correct a bad land use decision if you have one. And I think while he's well-intended, I think this is going to really muck up the whole section.
Mr. Chair, could I ask a question?
Senator Sherrill, Senator Morrissey, we got to move along.
I know, just one final question. Would either the patron or Senator Stewart, could you take a dual approach, pursue both paths at the same time?
I would think so, and I would just note that Senator Obenshain's bill doesn't say anything about writs of mandamus or certiorari, the one that we passed in 2014, and that's been on the books now for like 8 years, and it doesn't have any carve out for that.
Okay, let's move along. Is anybody supporting the bill would like to speak in favor of the bill? Anybody want to speak? Here we go. Speak in favor of the bill, and then anybody want to speak against the bill?
If anyone on Zoom would like to speak on this bill, please raise your hand electronically.
Mr. Chairman, members of the committee, my name is Guy Rolling. I represent VA ROA, which is a nonprofit organization. They polled their membership, and this is one of the issues that rose to the top, and that's why they approached Senator Servo about sponsoring this legislation.
So you support the bill?
Yes.
Okay. Next, you against the bill?
Mr. Chairman, members of the committee, Mark Flynn on behalf of the Municipal League. First of all, there's already a remedy. If a zoning official takes arbitrary action, whether it has willful disregard or not, you appeal to the Board of Zoning Appeals, and from there you can appeal to circuit court through a writ. So there's that remedy. And in the most egregious case, if there was an egregious case, it'd probably end up with somebody being charged with a criminal violation of the zoning ordinance. And if that's a bogus charge, there's already a remedy there. It's called malicious prosecution. And anybody would take one of these sometimes, a lot of times the zoning cases are really complicated cases, a lot of evidence. It couldn't go to district court. A district court judge would blow his mind, trying to deal with all of that evidence that he has to do. And third, we're concerned that, so because there are already remedies, and particularly appeal to the BZA and the circuit court, the concern is that the most litigious kinds of folks who don't want to do what the zoning ordinance says, if they have a choice between using this new provision and using the remedies that are there, why not roll the dice and go for one where you can get comp damages and attorney's fees? So we'd ask you all, we have real problems with it for those reasons.
Okay.
Also, and then the other thing is that apparently, even though this is in the land use part of 15.2, I think it would apply to any action in 15.2.
Question, Mr. Chair.
Senator, who's this?
This is Peterson.
Peterson.
And I've handled a number of these cases against local governments. You'll agree with me, under the Administrative Process Act, if a state agency violates the law and the citizen wins, they have a right to recoup their attorney's fees.
No, I don't do those cases, so
Well, just trust me, they do.
Okay.
There's a cap on it, but they have it.
Okay.
We don't have a similar right of recovery when a local government violates the law. Will you agree with me there?
I do, yes.
Okay, thanks.
All right, next, state your name.
Mr. Chairman, Joe Lurch with Virginia Association of Counties. Associate my remarks with Mr. Flynn. For those reasons, we oppose the bill.
Okay.
Thank you.
Next. Your name?
Mr. Chairman, Chris Ziegler with Fairfax County. We also oppose the bill. I'd also suggest that another problem that this bill is going to create is sometimes these enforcement positions are difficult for us to fill. And so if we lower the bar and allow an enforcement officer to be sued, even at the stage of when they issue a notice of violation to someone, that could trigger a lawsuit in this case. It's going to be even more difficult for us to fill those positions. So
Okay, anybody else? Senator Stewart?
Mr. Chairman, I'm sorry, I don't want to ask a question. No, I was just thinking while they were talking. So let me give you an example of where this could really be problematic. Say Senator Serval's got 100 acres somewhere and he wants to build a solar farm. And the solar farm actually gets permitted. And he's got 50 neighbors around that 100 acres that don't like it and that complain about it. You're now going to get 50 lawsuits in General District Court because his language says any person aggrieved. Right. It's not just the land use applicant. It is any neighbor that's involved with that decision.
Mr. Chair.
Wait a second.
Stewart
and so that's an example of why his bill is very poorly drafted. No offense, Scott. If you're looking for attorney's fees, then put it in the existing statute that says if you win the arbitrary and capricious decision, the suit by writ of certiorari or mandamus in Senator Morrissey's example, then you've got the ability to get attorney's fees under certain conditions.
Yeah.
But don't inject an entire new standard into this system because there are a whole lot of unintended consequences. And I really am afraid that you're going to end up harming people's remedies as a result of it.
Okay. Any other questions?
Mr. Chair.
Yeah, Senator
Peterson. I just want to respond to Senator Stewart. The word aggrieved is actually very critical because the word aggrieved has been defined many times by case law, Friends of the Rappahannock case, and then most recently the Andrews Larson Trust case, which was my case, which was decided almost exactly a year ago, which it's a very narrow class of people that can get into court. In other words, you have to be physically proximate, which has been typically you have to be touching the property. And secondly, you have to have a unique interest. I've litigated this, and believe me, you're not going to have 50 lawsuits.
Mr. Chairman.
Okay.
That's all I'm
saying. Well, we got to move along now quickly.
Mr. Chairman, I would just note the aggrieved language came from Senator Obenshain's bill.
Okay.
And I would also note that if Senator Stewart had voted with me on my class action bill a few years ago, we would have a class action. It's only one lawsuit instead of 50. But
we need to move this along. There's a motion to report the bill. Is there a second? Is there a second?
Second.
Is there a second? Okay, it's been moved and seconded to report the bill. All in favor of the bill, vote aye. All opposed, no.
Ayes 10, noes 5.
10 to 5, the bill is passed. All right, we got two more bills very quickly. Senator Deeds.
Mr. Chair,
1379.
A break from the Stanley Serval show with just 13 minutes to go. And I want to do 1534 first. That's the easiest one. That would allow the Sentencing Commission to share pretrial data with a longitudinal data system for data scientists and researchers to draw a more broad, meaningful understanding from the data. But because the data contains personal and case-identifying information, interesting issues, valid issues have been raised about the disclosure of this information. Therefore, I'd make a motion that we pass the bill by indefinitely and have the clerk send a letter to the crime commissioner, take a look at the issues regarding disclosure of this information.
Okay, it's been moved and seconded the bill be passed by indefinitely with a letter to me. I'm chairman of the Crime Commission. All in favor of the motion, vote aye. Vote opposed, no. Okay.
Okay, and the second bill.
Ayes 15, no 0.
I've got is 1495. It was in response to a case that was delivered by the Supreme Court of Virginia this summer that basically said an inmate treated by a doctor who was contracted to provide services, I think, at the Danville City Farm, was not entitled to malpractice damages. And I'm not certain whether, it's 1379, I apologize. I'm not certain whether one who was the victim of malpractice should be denied coverage, whether they're in a jail or out in public. And so that's simply what this bill's about. It might be inartfully drawn. I primarily am interested in contract employees who have malpractice insurance. I don't want to provide those people with immunity. But that's what the bill's about.
Anybody want to speak for the bill or against the bill?
If anyone on Zoom would like to speak on this bill, please raise your hand electronically.
Mr. Chairman, members of the committee, Mark Flanagan for the Municipal League. First of all, I want to start with what Justice Kelsey in the Danville case wrote the opinion. While sovereign immunity has stood the test of time, the testing process seems to never end. And since then, the sovereign immunity doctrine has persevered alive and well. And I think this may be a case of hard cases making bad law if this becomes law, and nothing personal. Senator and I have talked quite a bit about this. We think that sovereign immunity is critical for the carrying out of government services at all levels. And we think that this would be the first of 1,000 cuts where sovereign immunity would be eroded and raising the cost of providing services to all citizens. For cities and towns, sovereign immunity is important for snow plowing operations, responding to hurricanes, all of the public safety things that go. This is just an example of it. So what would be, if this goes through, what will be the next bill? Will it be for other local government employees? Will it be VCU Health, or VCU Medical Health, or UVA Health? With the bill, as you see, the bill says it's any healthcare provider provided in that section, and that section is pretty broad. It's nurses, therapists, counselors, and so anybody who's providing services to a jail. So if a city hires a rescue squad and has a nurse on board and they do transports from the jail, those nurses or those EMT folks would be involved in this too. So it isn't, I understand what the concern was, but it goes way beyond that. So, but the main thing is, it's not this case. It is about the importance of sovereign immunity that we all rely on. Thank you.
Mr. Chair?
Senator Morrissey.
One quick question. You make a good point about it's going to use your words, raise the cost of services. But I think the thrust of Senator Deed's bill is to raise the level of care for a prisoner. Which trumps which?
Well, actually, in this
care
particular
or cost?
Mr. Chair, if I may,
yeah.
in this particular
Mark.
case, the poor fella that got in jail, he, in a period of about 2 months, from November to February, he was sent by the jail, received medical care by the jail 6 different times. Sure. You know, it's sort of, I guess it reminded me from law school, the eggshell skull question. You take your plaintiff as you find him. But it's not like in this case that he did not receive care. So you know, I think that the real answer to that question is in any case of sovereign immunity, and I've used it as a city attorney, it's difficult, but it is unfortunately necessary with our structure that we have and our concept of how much the citizens of every locality and the Commonwealth should pay, that's the balance that has been reached. That's all.
Yeah,
thank you.
My view is to turn the localities into the state Tort Claims Act. They're not now. I've had bills on that.
Right.
Which the localities always oppose. Okay, all right, next.
Thank you, Mr. Chair. Phyllis Arico with the Association of Counties. We also oppose for the reasons stated previously.
She opposes the Association of Counties.
Mr. Chair, Elizabeth Hobbs with the Virginia Sheriff's Association. We also oppose the reasons stated, and certainly sovereign immunity does not limit exposure in cases of gross negligence or in the federal standard deliberate indifference. It is the ordinary negligence, excuse me, and it is a valuable tool, and we would ask that you not report this bill. Thank you.
Okay.
Mr. Chair.
Yeah, Senator Deeds.
I've got a couple of amendments that I think will put the bill at least in the posture that I intended. I'd replace healthcare provider on line 15 with the word physician, and I'd strike the last sentence after the word employment, period. This section, that sentence, I don't think it's necessary. The whole idea behind this bill was to make sure that people, no matter where they're treated, have the same kind of rights. And I think if you're subject to malpractice, so even if you're a resident of the county farm, of the city farm, you ought to be able to recover damages if that malpractice through negligence causes you harm or death. I'd move that amendment.
Okay, the amendment is to change the word healthcare provider to physician.
Yes, and strike the last sentence in the bill.
The last sentence be struck entirely. Okay, would the last sentence of the section serves to waive sovereign immunity.
And I don't think that, I think that's just, that sentence is
Okay.
extra, they're extra words that don't.
All right, is there a motion to adopt the,
Motion.
motion to adopt the amendment? Moved and seconded to adopt the amendment. All in favor say aye.
Aye.
All opposed, no. Motion carries.
Move to report as
Yes.
amended.
Okay,
Senator
before we
Peterson.
vote.
Mr. Chairman, we have a speaker on Zoom.
Okay, yeah, go ahead. Senator
Vic,
Peterson.
you may unmute and speak.
Yeah, Senator Peterson has a question.
Well, I'll let the Zoom speaker speak, and then I want to speak.
All right, okay. Zoom speaker.
Virginia has claimed sovereign immunity against disabled state employees because we've had those cases down there. Blatant harm should never be allowed, no matter what it is. Thank you for Senator Deeds to make sure that all people are created equally. Request that you move to report. Thank you.
Okay, next. Anybody else?
There are no more speakers,
Okay,
Mr.
Senator
Chairman.
Peterson.
Yeah, here's the problem with that amendment, which in a lot of ways is helpful, but it's not helpful, because then it raises the question, is this an exception to sovereign immunity? Sovereign immunity basically says you can't sue the sovereign, and a sheriff and the sheriff's deputies are the definition of a sovereign. I mean, Shire Reeve is literally, they are an agent of the king. And if we're going to say now you can sue, or you can have a cause of action against a physician who's an employee. Remember, this only applies to employees. If they subcontract, then that's wholly separate, and I've had those cases. But if someone is an employee of the sheriff and is basically under the sheriff's direct supervision, we've always said they are protected by sovereign immunity. That's one of the immutable rules that we've had. And now, the original bill said, nope, we're taking them out. Well, now it's kind of vague. Are we taking them out or not taking them out? And so, you know, I'm going to vote against this bill, not because I think it's a bad idea. It's actually a great idea, but you're going to be changing the relationship of sheriffs and local governments, but particularly sheriffs, to the state government without any sort of balancing of costs, insurance costs, anything. And I just feel like this is a much more major step than we're realizing at this point.
Been moved and seconded to report the bill as amended. Any further discussion? All in favor of the motion, vote aye. All opposed, no.
Senator Morrissey? Ayes 8, no 7.
8 to 7, the bill passes. Is there any other business to come before the body? If not, the Judiciary Committee is adjourned.